Hello to everybody. I'm Kurt Smith. I'm a professor of forestry at North Carolina State University, being joined today by Becky Smith, no relation, at Mississippi State University. We're normally also here with Renee Wyatt from Purdue, but she won't be with us today unless she just magically jumps in and takes a couple of slides. But this is going to be a lot of slides, so I'm going to give a little warning sort of in advance that this might be a little like drinking from a fire hose. And part of that is by intent. And so in a way, most of this, if you were to do this workshop with your clients, citizens, the idea isn't to explain everything in a full orbed way. The idea is to drive them to say, oh, there are so many options. I need to go see my attorney. I need to go see my CPA. So this is like a sampler, or if you're a football fan, like a highlights reel on Monday, so you can see what happened all weekend in 60 seconds. So don't feel distressed. And all of the presentation material, as well as extra material, is going to be available to you. So that's just kind of a warning, I guess, about today's talk a little bit. And I think we'll have some time for questions as well. So with that, kind of going through some of the housekeeping. Obviously, just want to acknowledge our organizations that kind of threw this together. I've already mentioned sort of NC State, Purdue with Renee, and Mississippi State with Becky, but also providing funding and guidance for this project has been North Central Regional Center for Rural Development, SRDC, which Roseanne is involved with, and the Institute for Family Business. So with that, going over this, and I'm going to roll pretty quick because I got to imagine some of you are rolling your eyes with, they're going to do these 6 slides again. So I'll roll pretty quick. But the purpose of this really is to get into succession planning. Succession planning differing somewhat from estate planning or being a subset or being a part of, sort of encompassing many of the emotional and financial aspects of passing on your family business or land, etc., to the next generation. So without, this is installment 3. So we're about halfway through, and there'll be more to come next Monday and Wednesday as well on this. So with that, let's see. Always a disclaimer in here that this is not legal advice, et cetera, et cetera. We wouldn't want you to quote us or take your individual situation and say he said, she said, because we don't know your individual situation, and legal law differs from state to state, et cetera, et cetera. I feel like that's intuitive, particularly with this audience. So, and this is that slide we have in there, just basically a slide for you if you are kind of running the show and educating people. These are just some things that you might want to consider running a workshop, etc. Definitional stuff, succession planning, we're referring to the transfer of management / decision-making abilities and authority from farm and assets, etc., during the life of the owner. Estate planning literally is the transfer of those assets after you're gone, after death. So 2 other definitions: the successor, we're talking about that junior generation that may or may not manage or own your land or business, and the incumbent generation, that person that actually, holds the keys to the car, so to speak, that owns it, makes those decisions about what he wants or she wants to do or not do. And businesses, we're talking about the actual operating of a farm, forest, or other business. Usually we see those reflected in things like LLCs, proprietorships, solar joint trusts, corporations, etc. When we say land, we're talking about everything: vacant land, pasture, farms, forests, etc., etc. So a little bit of definition in there. And I'm breezing through that largely because I think y'all have seen these slides before. So module 3, we're going to talk a little bit about intestate title, just a little bit, tools for remediation and prevention, some transfer options. And again, those are going to come at you pretty quick, but there's going to be a lot of material that you can read up on that'll be provided to you post workshop. Ownership structure and transfer, and then a few things on during life transfer and after death decisions. actually before death decisions, but regarding after death decisions. All right, that was a small joke. So, and also a final segment about things you should do. We talked about this at the last module about people were asking, what do you look for with your team, right? So there's a little bit of this is going to get covered. Things you're going to look for with your professional advisors, lawyers, CPAs, forester, farm manager, whatever. So we'll kick off a little bit talking about intestate title and tools for remediation and prevention. Intestate title, the three blocks we're talking about: remediating the past, which can be difficult, preventing intestate title / dying without a will in the present, and then also planning for the future. So a little bit of introduction. 40% of the nation's farm and forests are owned by pretty old folks. And this massive transfer of ownership, close to 400 million acres, is going to happen really soon, or in 2025, next 15 to 20 years. The great land exchange will happen through wills and probate, hopefully, and if not through wills and probate, then through land fragmentation. So it's a big issue. I work primarily with forestry owners. Most of my groups, when I go to talk to them, there's 80 to 100 people in the room. They're typically about 70 years old, and about 40% of them have no will, have no provision for the future whatsoever. And so that's problematic, which we're hitting on a lot in here for family unity, families falling apart, all those sort of emotional things. But it's also, if you're in forestry, as I am, that contributes to land fragmentation and land loss as things get divided up and things get probated with no mechanism in place to keep the farm or forest intact. So these land transfers are really important. It's so complicated because succession planning really is that human side, dealing with your kids, dealing with an aunt and uncle that has no surviving heirs, perhaps. So it's into that thing about, a lot of older folks. We talked about the example, I think, in the first module of the person that worked for their mom and dad on the farm for 15 years and they passed away, or they didn't pass away. The daughter decided she did not want to be part of the farm or forest operation. So she had definitely had developed differing values and goals. And so this is a problem that happens pretty frequently. So we're getting into succession planning to help describe strategies that will assist landowners to get that successful intergenerational transfer of assets and wealth moved across the board. So a little bit about lack of succession in estate planning. So what does that do? What if I do nothing? I frequently hear this from landowners. I talked to a 70-year-old. I mentioned, hey, you should probably think about, seeing a lawyer and getting this squared away. I usually get, I'm not worried about it. Don't care what happens. My kids will do right. I'll be gone. I don't care. I hear that. I hear that more frequently than I would like to. So this lack of succession will lead to, and we won't get into all the nuance, but heirs property dying intestate and land being passed informally from generation to generation or being viciously probated, I suppose. Um, so this lack can also lead to heirs property leads to loss of intergenerational wealth, leads to a lot of different things. Moving forward, in the present, it leads to things like partitioning of land. That's just sort of almost an involuntary action to sort of make all the heirs whole. I won't get too much into that, but and what do we look at in the future? I'm in North Carolina. We're second in the nation for land development. We will probably lose 1.3 million acres of prime agriculture and forest by the year 2040. And so where are they going for that land? They're going to ag land. They're going to prime ag land and forest land for that development. We're number two in the nation for developing, only behind Texas. And so the pressure of people being sort of almost in predation if they don't have their affairs in order is very real and has ramifications for our inventory of food and fiber and loss of intergenerational wealth going forward. So, what are some of the triggers that make people? So, if 40% have no plan, 60% of people do have a plan. What are some of the triggers that make people go after trying to see a lawyer and establishing a will, trust, or some legal architecture to deal with their affairs when they're gone, be it land or their business? Some of the triggers, as you might guess, are marriage because you've completely changed your unit, if you will, legally, or divorce, sort of the flip side of the same coin. So big impact on how your division of property might go. And also, is that a first marriage, a second marriage, et cetera, et cetera. Adopting or having children. All of a sudden, you now have heirs through adoption or through having children. So that is a big trigger. And of course, if you don't have a will or anything in place, every state has their own prescription about how the judge will probate and divide up your estate. So that's a line I use a lot with landowner groups. I use how many of you they worried about a will. I ask them how many of you would like the government to decide what to do with all your stuff when you're gone. And it gets loud in the room when you say that. Suddenly they get more interested in a will, a way for them to direct their assets, buying or selling a home. So it's a major loss of an asset or gaining an asset, buying or selling a home. That's probably one of your biggest pieces that you have to pass forward. And so that could be a trigger for setting up a plan to go forward, move a little quicker, new financial accounts. Most of us will inherit a block of money from our families at some point. That's going to change things for you. Sometimes starting or selling a business or a business folding will make a person say, I better start paying attention to what I'm doing with my estate and my assets. And moving to another state also can provide a trigger where you start to look at your assets and then realize that states deal with their laws of wills and trusts differently from each other. Obviously, death is one, but tied closely to that. And I think this is the number one reason, believe it or not, why people not marriage and divorce. It's getting that call about, the C word or heart condition or something makes people realize their own mortality and cause them to review their estate planning needs. That's like the number one trigger. And the other one possibly is changing wishes. Families fragment, or you find a favored person to take over your business, et cetera, et cetera. So I'll pause for just a second there and catch my breath, maybe even take a little sip of something. I said that like it was alcohol. It was not alcohol, it was coffee. So we're going to talk a little bit about educating yourself before you go to visit your attorney, tax specialist, or financial advisor. So a good thing to do, because you're going to do this to the tune of 250 to $500 an hour, whether you show up with the right things or not. Basically, a lawyer is going to say, well, I need to see everything you've got. And so the more you know and the more you have everything together and figured out or have some ideas in your head, the more time that will save you as you visit an attorney, which will make your visit more effective, more efficient, et cetera, et cetera. So this is a crazy graft, right? So this is the fire hose that I promised you. So these are some common, though not necessarily the only, and some of them get combined, common transfers for your land. So obviously, if you own land, one way to transfer is just to sell your land. And owners do this periodically. You'll have somebody with no heir or somebody that says, you know what, forget the kids, I'm going around the world on a boat or something like that. They'll just liquidate. Another common transfer that I've seen is just donating your land. Sometimes people, again, that have no heirs will seek to donate their land, usually in some kind of goal alignment scheme. I'm a conservationist, so I want to give that property to the, X, Y, and Z Land Conservation Trust, that kind of thing. Another common one is just having one successor and transferring it to them via trust or will. This is very common. And usually that's done if you have an heir, somebody that's really clearly interested in your business, farm, or property. And a singular ownership, I will go out on a limb and say, is typically always desirable for a lot of different reasons. The other option would be to divide land among your successors through a trust or will. So it makes clear what the division of property is. And you can also leave your undivided interest to all your successors via trust or will while you live. And this is not necessarily a good choice, but it is a legal option, and people do exercise it, and attorneys do write it into documentation. And then finally, you do have the option of doing absolutely nothing, like the farmer I described earlier said, I don't really care, I won't be here. The government will follow a prescription in your state. All states are different. They'll find your heirs. They'll find what they think is the best path to dividing up your property and setting it loose. Seldom does that mesh, or seldom does that gel with what the wishes of the deceased probably were, but it will take place. So, um, breezing through some of these is not to be repetitive. Obviously, you can sell your land and put that money to other uses. So I was joking about sailing around the world, but you can sell your land and then just put it in a investment that will yield you 3 or 4% through your retirement, because you definitely are getting out of the farm forest business or whatever business you have. So you can actually generate income without having to hold on to all that capital. Another option, another tool I didn't mention, which I'm mentioning now, is a TOD, transfer of deed on death. And that's something that gets recorded, and your heir's name is actually on the title. The beauty of a TOD in many states, I think I've mentioned before, in my county, it takes up to 2 years, 2.5 years to probate. During that time, your heir would have to pay taxes, provide the maintenance and upkeep, pay the utilities on your property, which can be pretty significant. If it's a TOD, it doesn't probate, it instantly goes to your heirs. So now what is the downside of that? What if the property or the person that's giving to you, comes with a lien, comes with a lot of debt? Well, you're also on the hook for that. So there's warnings with those things too. But if you're very solid and you know that the person wants you to have this property and there is no outstanding debt or problem, Todd might be something you want to look at. And these are some of the states where a TOD is an option. Some states don't provide that in their legal architecture. Many do. So that would be something you just want to talk to your attorney about to see what those options might be, if that seems like it fits you. Obviously, the main benefit is avoiding probate and expense and being able to do something with the property immediately. The main risk, of course, is you're taking on all of their encumbrances and claims or anything. If somebody had a lawsuit against them for $2 million, they may get a judgment and take everything. So there's a downside with that too. I threw this in just a little bit really quick. It's called a ladybird deed. I'll just encourage you to look at it. It's very similar to a TOD. North Carolina has this. Few states have them. It's a way for a person to list his heirs on the title. But if he goes in a nursing home and needs money, they can't take your home. It's got a lot like a TOD, but it's like a TOD on steroids. So it's called a ladybird deed or enhanced life estate, which is a pretty cool tool to look at as well. Not a lot of states have them, so it's a great way to not say to lose your inheritance to medical bills and stuff after death. They can't come for the home, that kind of thing. Um, Donating the land, I think we talked about that a little bit. Of course, even if you're donating land, you don't want to just say, hey, here you go. You want to talk to an attorney again or a CPA, because your tax strategy may be very different. You may want to donate that 10, 15% at a time over 5, 6, 7, 8 years or whatever, so that you have favorable tax conditions. Um, Becky, am I over talking? Am I past my slides? Okay, give me some kind of signal. All right. Donating the land, we talked about that. And of course, there's rules. Also, there's rules the IRS has associated with that. So you definitely want to work with an attorney if you're planning a scheme like that, especially while you're still alive, et cetera, et cetera. I will always advocate for selecting one successor because part of what my entire job is keeping land in a whole form. And so having one successor does that. Naming multiple successors invariably leads to, if any of you are familiar, have been on a GIS system and looked at property and lots, some of you may see on a GIS system a series that almost looks like piano keys, and you wonder what the heck is this? There's like eight 10-acre lots that look like piano keys. Well, that was probably where the land was divided. There were multiple successors, and so they had to divide everything evenly. And so the land that was once 100 acres now looks like a series of small piano keys. So having one successor is a great strategy, particularly if you have legacy interests, perhaps, or you just want to see your business go on intact, very similar to the way it was when you were alive and operating it. The other one, and this is not a favorable thing to do. This is the predecessor of heirs property and can create problems if even if you can leave your land undivided to all successors. So 100% of the people own 100% of the land. And the real sticky part of that comes if one of them dies and they have four kids. Now they're instantly four more in the equation that can sell out or cooperate or not cooperate. So not an ideal option. You avoid it if you can. Common legal remedies, or you could have a tenant in common agreement. So, or form an LLC, appoint the person most interested in running the farm or business to head the LLC as a manager. That would require everybody to agree on decisions, et cetera, et cetera. Um, a lot of different things you can do here. Again, my whole purpose in doing this is to maybe perk up your ears, or maybe the purpose for you, if you're teaching this, is to drive people to realize I have a lot of flexibility. I have a lot of options. Let me get clear in my head what I want to do and see if I can find a legal instrument that will do it with me. Probably the least of all ideal options is do nothing. Again, the judge, the court will decide exactly what is going to happen to your property, which could be not what you want to do at all. No planning for inheritance, estate taxes, et cetera, et cetera. So very problematic, and don't do that. So I think we're coming up. Thank goodness you're going to get to hear a different voice. So I'm going to pass it off to Becky.
All right, Kurt, thank you. Stay awake,
I
Kurt,
will.
though.
I will. I will.
Okay. All right. Just want to remind everybody to put questions in the chat. Hands up or something. We want you to get questions answered if we can. We will give it a shot. So, all right, we're going to take another deepish dive, but not really deep, like deep enough, I guess, enough to help people understand there are many tools out there, and that can be so that when you go see the professional, that they will be able to understand which fits best. But that's really, really key is seeing the professional. One of our goals with the curriculum is to help families be able to be ready to see those professionals. So let's talk about how businesses can be held. So um, the way that we're thinking about it is we're going to categorize into types of legal structures, or the way that businesses can be formed and held are things that happen automatically, forms that happen where the transfer can happen automatically. And so that we're call that group one. I've got a little diagram to show you here in a second. And group two is going to require some decision making. So we're gonna think about it like that. And here is the nifty graphic. So on the left-hand side, sole ownership, joint ownership with rights of survivorship and tenancy in common, those are going to be forms, and we're going to talk about each of these. But these forms are going to roll on. On the other hand, the group two, the general partnership, limited partnership, the LLC, the S&C corporations and trusts are going to, there's going to need some decision making that's needed in as far as in thinking about succession. Okay, so now we're going to just break down again, just introduce you to each one of these. So hang on with me. We're gonna get through the nitty gritty today. Okay, so sole ownership, simplest form, right? Where one individual holds a legal title and exclusive rights of possession. They legally make all the decisions. So under the legal form, right? The law, the ownership, every ownership has pluses and minuses, benefits, costs, we can say good or bad, but really they just have evolved to help get different situations. So some things are going to be better suited for certain families and certain businesses, and these others are going to be tools that are better for others. So that's really a lot of how we're going to talk about each of these, the pluses and the minuses. But for a
Yeah, and
sole
in
owner,
the case of sole ownership, there won't be a lot of liability help or a lot of tax help. So that's usually not everybody's first go-to, but they all, like your Becky saying, they all have attributes and just based on what you're thinking. Yeah. Sorry. Go ahead.
no, great, thank you. So yeah, so setup of a sole ownership, it's simple, low cost, and the taxes are reported by the individual. And so that just means that the the taxes are part of the individual's income taxes. There's no additional tax for the business, so that's a plus. The downside is that there's no liability protection. So that's a big negative, right? And then can only be transferred by will or deed. And that sole ownership ends when it's transferred out of the owner's hands. So highlights of sole ownership. We're going to talk about joint ownership with the right of survivorship. In a second, we're going to talk about without. So hold on. So again, joint ownership with right of survivorship. So this is where an ownership, where two or more owners share an undivided interest in the property. Again, so very much like the sole proprietorship or sole ownership, simple and inexpensive to set up. Taxes are reported by each owner. And again, that just means that it'll be part of their individual income taxes, not a company or business tax on those profits. So again, no liability protection. And this is sort of interesting here. So this is with the right of survivorship. So upon the death of one of the co-owners, the others automatically assume ownership. So that's with the right of survivorship. When
Yeah.
one owner remains, yeah, it's going to revert to sole ownership. And if one of the owners wants to sell their share, this will depend on the state. Some states allow a sale of that portion. But other states require obtaining consent from the other co-owners, and a sale cannot be forced. Kurt, did you want to
Sure.
say something?
Just a simple way to explain it is that if I and my brother have a business together, it's going to be last man standing. If he dies before I do, then I get all of his share and vice versa. So it's kind of last man standing. So that's kind of it. All the rights extinguished with the death and transfer 100% to the last survivor. Yeah. So,
Thank you. Excuse me. So tenancy in common. So joint ownership. This one without the right to survivorship. So several implications. Interest can be transferred via will, and then, of course, we'll go through probate. So owners can force a sale or sell their interest without consent from all the other owners. So that's really the difference with the right to survivorship, which is with the rights of survivorship and without. So additionally, with tenants in common, the ownership will continue until it's sold, until there's only one owner. Again, at which it goes to sole ownership. So again, set up simple and low cost, and again, taxes reported by each owner. No liability protection. So those were the ones where the firm, Kirk called it I'm going to go back to the original graph here so we kind of see where we are. So requires you to do nothing. So Kurt, would you kind of give more language to that? So do nothing, right? So the two groups we're thinking about, there are decisions to be made at certain points in time. And that's really how he's thinking about these two differently.
Sure, I can uncloud it or make it easier, but yeah. So I mean, I think the first one in group one, which I think Becky pointed out well already, are things that are going to happen. They don't require much legal architecture. Tenancy in common will just happen if somebody dies. The joint ownership with right, those are sort of automatically set up. Sole ownership, I have it. I own my house now. That's sole ownership. But these other ones in group two, which this is where it gets kind of funky to me, is it's transfer of assets, but also transfer of business, and it can be while you're alive or while you're dead. So these things definitely 100% require an attorney to know what you're doing, and they all have upside and downside depending on your goals and what you're trying to do. Don't know if that helps, but there you go.
Yes. So thanks. And then we're moving into ones where we really need to talk more about operating agreements as well. So we'll come back to that concept. But Flora in the chat has just asked, can you buy liability protection? So that's an interesting question, given we just talked about these types of legal structures that don't have liability protection. Can you buy liability protection in a different way? Very interesting question. So, let's go through. This is how, Flora, this is how most people do it. When they want the liability protection embedded into the business, then they will use different forms of legal structure. So let's go through those, and maybe we can come back and talk about the Flora's question after we go through these slides. So, all right. So with a general partnership, so two or more co-owners or partners establish and organize, it's a for-profit entity. Setup is a little more complex and expensive. The partnership files a tax form. So the plus of this is legal liability. Where's the liability here? I'm getting out of myself. But the negative is sometimes we call it double tax. So as an organization is formed, then you're going to have an additional tax of the business, and not just through the individual's income tax. So it's a little bit more complicated as far as the tax structure. Partners can have unequal interests in the business, but are liable for all its debts and contracts. So partnerships may terminate in the case of death, of bankruptcy, exit by a partner, but its interest can be passed on to heirs or disposed of in a buy-sell agreement. So there's a lot of language in that. Kurt, do you want to add something there?
I don't know if I have a ton to add. So again, it's a pro and con kind of thing. So yeah, you file taxes as a partnership, but you'll pay your taxes as individuals. So there's definitely a little more care and paperwork. If you're not inclined that way, that might not be the way to go. And yes, a buy-sell agreement is always a really good idea if you're in a partnership, for sure. So it spells out the terms with the person you're in business with for getting out or getting in. Like, I get a right of first refusal to buy you out, or you can't do it without my permission, or fill in the blank. So it makes sense to do that.
So the buy-sell agreement is something that can be added, which like the other forms we already talked about have that built into it. So it's a very, the way this has have evolved, they're trying to add flexibility into these structures. So limited partnership. So we talk about general partnership, and now we're going to talk about limited partnership. And so only differs from the general partnership and that offers limited liability protection to some of the partners. Those are the limited partners. So general partners are managers and they assume personal liability. So it's kind of interesting, just the spectrum of liability protection and the no liability protection on the one side of the spectrum and liability protection on the other. And this is sort of in the middle. So it depends upon your role in the organization. So limited partners only own shares and thus get protection from liability, but lose that protection, of course, if they become the general partner. So limited partnership can also be used to involve younger generations, allowing them to become invested in the partnership. Kurt, tell us about that and how that works.
Let's see. So an example might be my kids will only own 10% of the business and they may not be actively involved in the business at all. So their liability is removed from it because they're not actually making decisions. So you're not liable for those decisions. But it can be a good way to involve people that you think they're going to take over the business one day, or they're going to become more active when they get through college and have their degree and, whatever, agricultural, whatever. So that can be a nice tool to do it. But yeah, the issue of liability, we'll talk. It'll come up more in these slides. So
Yes, it
hopefully,
will.
if nothing else, you see that there's a lot of different versions. So yeah.
Absolutely. Yeah, and again, so thank you. Regulations vary by state. Formation of a limited partnership must be reported to the state. Okay. Business can end with the death of a general partner, but limited partnership agreements, wills, and written agreements can be used to avoid its dissolution. And in this case, taxes are filed like a general partnership. Okay, so one that we're much more familiar with, we hear about all the time, the LLC, creates again a for-profit entity. I don't think we're talking about nonprofits today, are we? At all. So all of these are for-profit entities, combines the liability protection of a corporation. So that's something that's desirable with taxation and the flexible structure of a partnership. So all owners or members avoid the personal liability and they can define the management structure. So in the sense of the succession conversation, the interests can be transferred through gifting, through selling, or through a will. The lifetime of an LLC can be indefinite. And a written operating agreement is required. We didn't talk about operating agreements in the previous ones, but let's talk about operating agreements now. In the sense of simply an operating agreement, the best as I understand it is what's going to happen when somebody passes and so that the business can keep functioning. So an operating agreement is very, very important for people, especially people that are getting income from the operation. If the operation doesn't have an operating agreement and things get bogged up, then people who depend on that income can be put in, they might not have access to these funds for a very long time. So that's really important.
Yeah.
Um,
I think we could talk. LLCs are like the candy. They're just everybody loves LLCs now, and with good reason. They're really really valuable, and they can be combined with different types of legal architecture as well. So one way to think about this is if I was the owner of $1 million farm and I hurt somebody or lost a court case, they can come after me to be made whole, and I can lose the whole farm. If my farm and all its buildings are held in an LLC, that is not me. The LLC is not me. The farm, the building is not me. They cannot sue. They can sue me, but all those assets are off the table completely with an LLC. And so it's very valuable. Most states it's $100 or $200 to file it. Um, so that the liability is fabulous with LLCs. But it also can be a business tool because you can get, for example, heirs property folks can get together and they can just have the one guy that lives on the farm operate the farm as the manager and have an operating agreement, and all the heirs can be in on a vote to decide if they approve of what's going on. Same with selling. So they couldn't sell if it was an LLC without the permission of all the people in the LLC. So all of that to say, this is a tool that has a lot of flexibility and a lot of different applications.
Thank you, Kurt. So the operating agreement is a requirement. Also, a business meeting, don't they have to do an annual business meeting?
The year, I can only say this because I'm a part of an LLC. It can be pretty informal. You can go to the beach for the weekend and talk about your business. And you take minutes of the meeting and you send it to the Secretary of State in most places. And that fulfills that requirement for your LLC. So don't be afraid of that.
Very nice, nimble tool, relatively inexpensive. So everybody likes it. All right, and S and C corporations, going to hit briefly. So entities that have rights and liabilities separate from their owners or shareholders. Corporations are heavily regulated, so higher setup costs, must file their creation with the state. Shareholders elect a board of directors who then appoint officers or others to make the day-to-day decisions. Corporations don't have reduced capital gains tax rates and are taxed on their earnings. So this is the plus side is the liability protection. The negative is that double income tax. Owners are taxed on the individual income, but then the business is also taxed, as we mentioned.
Unless it's an S corp. And so
Unless it's an S corp.
there you
Okay,
go.
here we go. So the C corps taxes entities, and the S corps avoid that double taxation. In its limit is limited in its number of shareholders and types of stockholders.
So if you have a business with a couple of hundred employees, you can, or even 100, even 50, even 20, you can't qualify as an S corp. It's usually if it's 3 or 4 people, you can form an S corp. So that's one of the big differentiations, I think. And of course, it's great if you only get taxed as individual income. So what a lot of people do is you put all of your things that are sort of brick and mortar, my tractors, my buildings, my house in an LLC so nobody can take them. And then they put their actual business, their profit they make, the actual business part in an S corp. So they protect all of their assets and they get the tax benefits of an S corp if they're small. And I see a lot of farms. That's kind of what I tell people to do. So it's a lot of advantages that way. So that's one where you combine things and you get a lot of advantage.
So you can mix and match. So
Yeah.
yeah, so really helpful to go to an attorney that really understands all of the different options and can see how what your specific operation needs to be protected. Trusts are another form of ownership. Can be used to transfer land. So legal entities where there's a separate legal ownership and beneficial owner. So the trust will own the land, not the people. The people become the trustees, the owners, managers, that kind of thing. You can be your own trustee, but the trust will own the land. So that's kind of an interesting, different way that people are not used to thinking. So, but divides the management of the asset from the benefit of that asset. I was trying to say, the grantor settlor creates the trust and its provisions, and the trustee manages it, and those can be the same people. There we go. So also a very popular tool, flexible tool. Some quote, there are as many trusts that are available as the situations that deem them right necessary. So freedom to develop why, how, when the assets will be dispersed to the beneficiary, as well as determine the amount of the discretionary power that the trustee has. Can elect to have a trust disperse assets while they're alive. So a living trust or a trust for a testamentary trust. So that would be after the passing. Irrevocable versus revocable. So you can see there can quickly get into lots of different types of trusts and different dimensions and the different trees of that are out there. Thinking about the types of trusts. So revocable is useful because it can be amended or revoked at any time. Irrevocable is useful because it doesn't do that, right? It helps move assets out of the grantor's or settlor's estate, but it can't be easily amended. So depending on what you need, you would decide which one that you would use.
They're like the most flexible things on earth. It can be dead, alive, revocable, irrevocable. So what does that actually look like, in reality? So I may have what's the right word? Uh, a son that's a drug addict or has no mental capacity to take care of himself. I wouldn't want him to have the money when I die. I would want a trustee to release the money over his lifetime slowly to protect him, would be one example. I've seen all kinds of wacky trusts. I've seen one where a group of heirs, property owners, put all of their stuff in a trust, and all of any heir, any of their kids could use the assets in the trust to take out a no interest loan to go to college. They would have to pay the trust back. And so I mean, you can let your imagination go wild with your attorney and use this as a tool to accomplish something. So those are just like a couple of examples.
Kurt, this is you.
Yeah, I was looking at that. I was thinking this should have been you because farm considerations. I'll take a run with it. So you jump in if you know more. I'm like a forest guy, but so for smaller and you should pick up on some of this language from what Becky was talking in prior slides. There's advantages to S corps or C corps, and so you want to explore those. So it can manifest itself through reduction in payroll taxes, commodity wages, tax-free fringe benefits, earned income tax credit possibilities, et cetera, et cetera. So not to be too prescriptive on the options of corporations, but be aware to explore which is best for me and my goals with my farm or forest. So larger forms, and of course, I wouldn't say these can't be hard and fast rules because it depends on the composition of the ownership, the goals, et cetera, et cetera. But this slide was prepared just to give farmers ideas about what are some of the advantages based on whether you're a large farm, medium farm, or small farm, et cetera, et cetera. And you can see all of those bullets that there's advantages and disadvantages in each. And so again, this would be something not to look at our slides and check boxes next to it. It would be for you to say, go to your attorney and say, I hear there's advantages based on whether I'm doing an S Corp, C Corp, LLC, depending on my farm being small, medium, or large. What are those advantages for taxes and transfer of assets? So, and then there's a little slide. This is pure farm. This is why I was trying to punt. So, machinery can be held, and this kind of is consistent with what we talked about. You can take your bricks and mortar stuff, keep it in an LLC separately. So that means if somebody comes after me, they're not going to get that stuff. So you can hide away your trucks. You can hide away a lot of these things. Hide's probably the wrong way to say it, but you can create an entity that holds it.
Shelter,
Yeah, there you go. So,
shelter.
um, other tools that we didn't talk about for your property are leasing. You can maintain some control. Am I into your slides right now? I'm not actually. Leasing could be an option. You can have control over your property, but have a manager there to take care of it. So that can be a great option. You know, I'm too old to run the farm, but I'm going to hire somebody to, and you see this very commonly because people want to maintain their present use value status, but they're too old to farm. So they lease it out to do whatever, 20 acres of soybeans, and they get the reduction in present use value. And they have somebody leasing the property that really wants to grow commodity or something. So that's a nice option. Conservation easements. This is kind of a wild one. This is the Wild West. We'll talk a little more about that, I think, in the subsequent slides, but um, conservation easements, basically, I'm going to jump forward a couple slides just to get to the conversation. I like to think a good way to think about easements in general is I own a piece of land. I own all kinds of things that go with that land. There's timber on the land. There's water that flows through the land. There's wildlife that are on my land. I could sell off a piece of my land. Those are all rights that I possess, and they're all severable. So I can take any one of those. I could take my timber for the next 200 years and tell Weyerhaeuser, you can buy the rights to cut my timber for 200 years for this number of dollars, and that will be honored and established with your property. So that's what easements are really doing. So in a like way, and there's a lot of this going on now with the threat of sort of valuable property, people, conservation agencies that want to have things like wild places, parks, clean air, clean water, maybe we could call them ecosystem services. They're willing to pay landowners to not develop that property and to maintain it for other things. So they'll pay for it. There's a number of programs run through land trusts, and also almost every state has a certain amount of money set aside to help protect those kinds of lands. So that's what a conservation easement is. And so that can be something that is, I know a lot of people that pursue that with a portion of their property, if not all of it. And again, it's flexible because what you're really doing when you sell an easement, you got a buyer and you got a seller. So whatever you agree to sell and buy, that's between you, and the lawyer can construct it. So for example, I have 100 acres that the Conservation Trust of Zambia wants. Well, I can say you can have 95 acres of it, and I'm going to put a building envelope in there for my heir in case he wants to have a 5 acre, and whatever you can get an agreement on. So it's the willingness of the seller and the willingness of the buyer for conservation easements. And there's a lot of activity along that line, and probably more down the road as land decreases, as populations expand, et cetera, et cetera. So this has got to be you, visiting professionals. You're on.
Yes, I'm ready. I have the ball. All
All
right.
right.
So again, really trying to help our landowners be ready to go to see those professional advisors. Lots of tools in the curriculum to be able to do that. So before they go visit, they want to use the tools in the curriculum that we've got here. We're going to highlight a couple of specific state resources as well at the end of the presentation. We're getting close. Consider the abilities of your heirs. So really thinking about what is viable sometimes these decisions are really complicated and we wish it could go one way, but practically and realistically, they may need to go a different way. Thinking about, who really is best for the job, and getting outside of our emotional selves. So setting goals, long-term, short-term goals, and that's really for the business itself, but also for the process of the succession planning, which can take intention to be able to follow through. Obviously, you're doing your due diligence. The professionals are expensive, and so you come prepared. More of them will be likely to work with you. So just getting somebody to call you back and getting time on their calendar. And then also less time is spent with them, and that will save you money as well. So you're gathering your documents, you're talking with your family, you're applying some of the things that we've already been talking about in the series, and learning about your options. So, like we are doing today. Lots of handouts for you. As this one, we're highlighting the estimating the value of your assets. And so creates a record of the inventory. Sometimes it is just really hard to think about, like to go specifically, like that's kind of like this big thought. Oh, what are our assets? Well, this will help you slow down and help you remember about what's out there. So, and you want to have a good understanding of what you've got. So sometimes it's easy to forget. So an inventory, and again,
That's a continuation sheet. So
yes, yes,
lots and
there's
lots of assets.
lots of assets. And so you can see that if the worksheet will help you think about the different types of assets that your business might have, so that you're not, taking those for granted, and you realize, oh, this is an asset. You might not have thought of it as an asset before. So just knowing where, I find this one to be really, really important. So really knowing where the documents are. You've got a lot of documents out there for the different folks that you're working with and the different systems. So this is a worksheet that can help you record where to find those, where to find the deeds, the titles, the bank statements, the insurance policies, the wills.
It
So this
sounds, it
is really
sounds,
important.
yeah, it sounds really intuitive, but I have a really old dad, and if he dies, I mean, or if he wasn't prepared, I mean, I might spend 3, 4 months trying to figure out where the heck all his
Yeah.
insurance policies are and who I need to contact. So this gets it in one place for your heirs, which
I
is
think this
pretty
is really,
important.
yeah, it can be really, really messy. And this is like the key worksheet that whenever I do any of the estate planning workshops, this is a key worksheet that I really, really hammer on. So because of what Kurt said. So if you can't find something, you don't know it's there, it can really be hard to locate. So we've got an emotional attachment scale. So this form helps you reflect about the feelings, the land, business, encourage you to think about the passions and what's really important to you. What is it you hope to accomplish with it? Is it Kurt talked about the different options at the beginning of the presentation. So this is going to help you think about that. What's important to you? Is it the conservation? And so maybe there's an entity that's going to do that better than your family, right? So is it the income that can be generated, right? Is it I got to learn about the Bulldog Forest at a forestry meeting recently. So MSU Bulldog Forest is happy to take your forest, your land. So, maybe you have loyalty to your alma mater. So thinking about what are your values here in this worksheet?
That's a good. Can you back up for a second? I'll chime in a little on that one too.
Okay.
It sounds kind of. I'm not the soft skills guy, so it sounds kind of oh great 10 point scale, but it really does impact thinking about, if you have no attachment to your property at all, then, maybe just liquidating my property when I'm a little bit old and putting it into a retirement account that'll give me a yield is the way to go. And if it's legacy and it means so much to me, well, I might have my son do it, even though he's not a very good manager, but I may invest a lot of time and effort to get him to do it. Or if I just look at this as a business, I'm going to cut my timber every 30 years. I don't visit this property. I'm going to hire the best forester and manager I can find to give me the highest income, the highest yield, etc. So it sounds a little, I mean, to me, it's a little whiffy to think about that, but it really is important to sort of have straight in your head how I feel about the property. So I just
Yeah, I
want to,
think it's really important for you, but obviously also for the incumbent or the successor, right? So thinking, are we on the same page, right? As another, these are just more tools to be able to improve communication between the in that succession planning. So another handout that we are highlighting, there's lots of handouts in there. We're highlighting a few today. The legal and financial instructions. So record legal and financial documents, making up the estate plan and their location. So just another helpful handout, keeping everybody organized and on the same page. And you can see what the ownership structure, the operating agreement, the buy-sell agreement. Again, where are they? Trying to keep everybody being able to know where everything is. And Kurt is going to take us to the end with this one.
yeah, I can do that. I move really quick. So there are a lot of tools out there. So show you a couple. Really, it's creating a thinking map is really what you're trying to do. So you can be clear-headed, clear-eyed about what you want to do, why you're doing it, and who's going to be a part of that plan. So there are a lot of tools out there. This one's incredible because I wrote it. So this is the NC State one. So if you're interested in this, this is really simplistic. And it pretty much applies to every state. So this is a workbook you could give to your parent, grandparent, or you could work together on it as a family. And it just kind of walks you through about 13 worksheets, everything from how to plan a family meeting to how to list your assets, etc. In fact, you've seen a few of the sheets that Becky highlighted prior are coming out of this workbook. So you could just download that and use that if you care to. And then honestly, this is Renee's, I think, from Purdue. It's probably actually better than mine. So it's a lot more in depth and a lot longer. Probably has a little more of a tilt towards agriculture as in farm. So, these are two, but I got to tell you, there are probably a dozen out there. I can hunt around the internet and find ones from Oregon State, ones from Virginia, and they're all essentially great tools.
Also, Wisconsin,
Yes,
Oklahoma State, ties to the land. So lots of
yes.
other really good ones out there.
However, this one, this
Depending
one is,
upon
ah,
your state may already have may already have a nice
yes, but
one for
this one
you.
is real,
Mhm.
really, really fabulous. So, all right.